Hello and welcome to another Rush Generations Health Education Lecture. Rush Generations and our staff is delighted to be your source of information, resources, and health promotion programs that help maximize your well-being and good health as you age. Today is Wednesday, August 6, 2025, and I'm Franco Sambataro. I'll be your moderator for today's lecture, Understanding Advanced Directives. Before I present to you the wonderful speakers joining us today, I'd like to first thank Hannah Weinsman for helping with the production of this lecture, helping us manage the chat and other key aspects so that we can all have a great conversation about the different types of advanced directives. As always, we're live streaming this lecture via our YouTube channel using the video platform Zoom, which allows us to host a good number of people who join us via phone. Thank you for joining us. And for those on YouTube, we ask you to please use the chat functions to ask questions and or to add to the discussion throughout the lecture. We will ensure that your comments and questions reach the presenter. And for those of you listening to the discussion via phone, you'll also have a chat opportunity at the end of the presentation to unmute your audio so that you can ask your questions. We want to remind you that all information offered here is for general informational purposes only, and to always seek additional professional advice for situations specific to you and your needs. Now, without further ado, I'd like to introduce our speaker for today. Our speaker is Kate Milvert. Kate is a staff attorney at the Center for Disability and Elder Law, working with Sedell's monthly community legal clinics throughout Chicago and suburban Cook County. Before joining Sedell, Kate worked at Equip for Equality, where she represented adults with disabilities in guardianship cases and provided assistance with setting up alternatives to guardianship. She also served as an attorney with the U.S. Department of Education's Office for Civil Rights in Chicago, investigating civil rights complaints against schools, colleges, and universities. Kate received her Bachelor of Arts in Indiana University, Bloomington in 2019 and graduated from Harvard Law School in 2022. Prior to attending law school, she worked as a direct support professional, providing home and community-based services to clients with intellectual and developmental disabilities. Thank you for joining us today, Kate.
Thank you. I'll now share my screen to present some slides.
We're looking forward to it.
Wonderful. Thank you all for joining us for this afternoon's presentation. I'm excited to be here and to share information about some important future planning legal tools, including powers of attorney, living wills, and other advanced planning documents. Legal tools that are designed to plan for the future and make sure there's a plan in place for if an emergency situation arises or for end-of-life care. To share a little bit about our organization and how we can be a resource first, the Center for Disability and Elder Law is an organization that provides free legal services to older adults, 60 and up, and persons with disabilities throughout Cook County. We've been around for about 40 years, and I'll just briefly walk through a little bit of information about our programs and the services we provide. Our main programs include our community clinics programs, which is what I am primarily responsible for, where we operate monthly legal clinics spread throughout Chicago and the suburban Cook County to be able to meet people closer to their homes for in-person legal services appointments. We also provide assistance with powers of attorney at various locations throughout Cook County to be able to provide assistance closer to home with setting up power of attorney documents, which we'll be focusing on today. And then we provide assistance for low-income homeowners on making plans for their home and making sure that they can successfully pass on their home to the next generation without any issues. And lastly, we provide assistance with adult guardianship, where someone needs to have a court-appointed decision maker appointed if they're not able to make decisions for themselves. In terms of our general program areas, what I'll mainly be focusing on today is powers of attorney and living wills. We also provide assistance with some other estate planning documents like wills and transfer on death instruments for real property. We provide a range of assistance with housing, other real property issues, as mentioned, guardianship, consumer debt issues, and simple divorce cases. For who we serve, we, again, as mentioned, work with people living in Cook County who are over the age of 60 or living with a disability. We prioritize lower moderate income clients, and we assist with those legal issues that I just walked through. Now, for the topic for today, advanced legal planning. Our main message here is not to wait for the crisis. There's a lot of pretty simple legal tools that I'll be presenting on that can really serve to make sure there's a plan in place before a crisis situation arises. To make sure that the people that you trust are able to step up and make decisions for you about medical issues or financial issues before a crisis situation or emergency arises. There's a lot of different reasons why advanced planning is important for medical reasons, financial reasons, legal issues, to be able to minimize stress, financial problems, interpersonal conflict within families, or health harms that are associated with not having a plan in place for if decisions need to be made in the future when someone's not able to make those decisions for themselves. Planning can take a lot of different forms. I'll be focusing on legal planning, like setting up advanced directives. But it can also involve non-legal planning that I know this series provides lots of other information and resources on, such as seeking out coordinated healthcare, planning for non-medical long-term care, making sure there's a plan in place for housing, and many other areas. And it's important to have planning in advance, not just for end of life planning, but also for when anything else might come up. Things can come up unexpectedly. As sudden unexpected hospitalization might impact decision-making abilities. There might be extra hurdles if transportation or housing instability become concerns. There might be simply changes in someone's family or support system that make it important to have ongoing conversations and ongoing thinking about the best way to have a plan in place for the future. Advanced directives are really intended to be advanced planning. So before a situation arises where you're not able to make decisions on your own behalf. What that means is that you have to be in a position at the time you set up the documents to understand what you're setting up and have what we call legal capacity at the time your legal planning documents are put in place. What that means, legal capacity, is the ability to understand the nature and effect of the document that you're setting up. And with that, there can be different levels of capacity for different legal documents. Some legal documents are more complex than others. For instance, it may take a different level of capacity to set up a will, where you need to have be able to understand all of your assets or property um, in comparison with setting up a power of attorney, where you're needing to understand that you're putting in place another trusted person to step up and make medical decisions for you if you need it. With all of these documents that I'll be talking about today, it's important to note that it's the person in our client or the what we call principal in these legal documents who is the one guiding and setting up the documents themselves. Often we get calls from children, loved ones, nursing homes even, who say, I want to set up a power of attorney for my father or for my brother. It has to, the request and the person who themselves has to be the one asking to set up these documents. So the father or the brother has to themselves be the one making that decision that they want to set up these documents and want to be naming someone else to step up and make decisions for them. So it's something that the whole idea is to give the person setting up these documents the agency to make that choice in advance of who they want to put in place for making certain important decisions on their behalf. No one else can be the one stepping in to make that decision to set up or not set up these documents. For powers of attorney, sometimes called POAs, there's certain formalities, legal formalities that have to be in place for these documents to be valid and effective. First of all, importantly, these documents have to be in writing. Sometimes um, it can be an issue where we all naturally have these conversations with our loved ones um, about who we want to have step up if we're not able to make decisions on our own behalf, if there's an emergency, or we're simply not in a position to make a decision due to medical condition or other reason. Those conversations are extremely important, but for that person to have legal authority to step up when needed, that has to be reflected in writing in a power of attorney document. There's standard state forms for powers of attorney in Illinois, and these forms we often recommend, and we ourselves use them in preparing powers of attorney when we're working with clients individually. And the benefit of using the standard state forms that are put right in Illinois' statute on powers of attorney is that they're widely recognized. They're familiar to healthcare providers, they're familiar to financial institutions for financial powers of attorney, and they're also pretty straightforward documents that are designed to be standard and more easily readable for people setting them up. For the power of attorney for healthcare, Illinois law requires that it be signed by at least one witness who's in addition to the person setting up the document. Um, and for the power of attorney for property or finances, it requires at least two witnesses, and that document must be notarized. We recommend often that someone includes two witnesses on the power of attorney for healthcare and also get that document notarized, even though it's not required under Illinois law, because some other states do require those additional formalities for powers of attorney for healthcare. So it can be beneficial to have that included to help ensure that the document would be recognized if, say, you're traveling to a neighboring state that requires those extra formalities. For powers of attorney, the main function of them is to set up someone else who you trust to step up and make medical decisions for a healthcare power of attorney or for a property power of attorney, financial decisions. And that person we call an agent. An agent under the law in Illinois can be anyone who you choose, who is at least 18 years or older. They have to have legal capacity to make decisions, meaning they can't themselves be under guardianship. And they also can't be a healthcare provider, or an attending physician for the healthcare power of attorney. It's a separate question on who should be the agent. I just walked through who under the law can serve in that role. But there's some other considerations for who would be best suited to serve in that role. It's important that that person be someone who's trustworthy, who you know you can rely on to know what your wishes are and follow them. They have to be someone who you would trust to step up and make decisions if the situation were to arise where you couldn't make those decisions for yourself. Under the law, the person you name in your power of attorney documents is not legally obligated to step up and make decisions for you. They could choose not to act. But ideally, you would pick someone when you're setting up the document who would take that active role and step up and make decisions for you if needed. Should also be someone organized, and someone who's really well suited to whichever type of decisions you're having them make for you, either medical decisions or financial decisions. Sometimes those might be two different people. Sometimes there might be one person in someone's life who you would really trust to make medical decisions for you, but who might not be as good with managing finances. It's completely okay to have two different people for each type of power of attorney. And then lastly, it should be someone who respects your wishes, who would defer to what you would have wanted, and who's not going to step in and assert their own wishes and preferences over yours. For powers of attorney for healthcare, what that covers is when it takes effect, it gives the person named as agent the authority to make personal and healthcare decisions for you, to the same extent as if you were making those decisions for yourself. If there's anything that you wouldn't want the person named as your agent to do in terms of healthcare decisions, there's the option to spell out right in that power of attorney document that you don't want someone making a particular kind of medical decision on your behalf. Along with having the authority to make medical decisions, the person named as agent also has access to your health information and records, if you're not able to make decisions for yourself. With a power of attorney for healthcare, you keep the ability to revoke that document at any time. You don't have to have capacity to revoke the document. So, if there would be any reason why you would no longer want that person to be making medical decisions on your behalf, you could simply choose to end that document at any time. There, with power of attorney for property, I often prefer to refer to it as a power of attorney for finances because it doesn't just cover things like real property, or it instead covers a really broad array of financial matters. With the power of attorney for property, the person named as the agent, the decision maker, has the ability to make financial decisions when someone's unable to make those decisions on their own behalf. This includes things like making decisions about assets, finances, bank accounts, other types of property. If you have real estate, it can cover that. One difference from the power of attorney for healthcare is that while you can choose to revoke the power of attorney for property, you have to have legal capacity to revoke it. So at the time that you're choosing to end the power of attorney for property, you have to be able to understand and communicate that wish to end the power of attorney for property. For a little bit more detail on the full range of what's included in a power of attorney for property, it includes, as mentioned, a broad array of financial decisions. It includes things like real estate transactions, being able to sign a lease, anything with banks, managing bank accounts, accessing accounts, opening accounts, things with insurance, retirement plan transactions, tax matters, other and a pretty broad range of things that at first glance might not seem to fully apply to one's own financial situation. Often it can be beneficial to kind of leave open this broad array of default powers that an agent under a power of attorney for property has in the standard Illinois form, because you never know what might come up for your own financial situation in the future. Things like real estate transactions, for instance, at first glance, it might not seem to apply if you don't own a home, but it includes things like signing a lease, which can be really important for planning for future housing and living arrangements. If there's a situation where you're not in a position to be able to sign a lease document on your own behalf. In addition to power of attorney documents, which, as mentioned, those are designed to allow someone else to step up and make decisions for yourself, for you, if you're not able to make those decisions for yourself. There's also a few additional documents, types of advanced directives, that can be useful in guiding specifically end-of-life care preferences. The first of these is a living will declaration. And that is a legal document that reflects a personal statement of end-of-life choices. It doesn't itself authorize anyone to do anything, but it is a document that can guide someone, including an agent and under a power of attorney for healthcare, in making the decision to discontinue life-sustaining treatment. A living will declaration is a way to reflect a preference and make a statement that if it were to be a situation where you're unconscious and a doctor has determined in accordance with reasonable medical standards that you're unlikely to regain consciousness or recover, It can reflect a preference to discontinue life-sustaining treatment and pass with pain management. Again, it's not something that is authorizing anyone to take a specific action, but it can help guide someone, especially an agent under a power of attorney, in making those end-of-life decisions in accordance with what your preferences are, and have that documented in a formal legal document. Additionally, there is what's called a practitioner's order for life-sustaining treatment, or a POLST for short. A POLST is a document that can be set up in consultation with a medical provider directly. And it's a medical order that specifies a patient's advanced decisions about what treatment they do or do not want to receive. This can include things like cardiopulmonary resuscitation or CPR, intubation, mechanical ventilation, artificially administered nutrition and hydration, among other types of medical treatments. And again, this is something that often involves a very detailed and ongoing conversation with medical providers to make sure that it's reflected in if that your preferences are reflected in your medical treatment plan, based on what your current medical needs and condition are, for especially planning for end-of-life care. I've talked a lot about powers of attorney and how those can be important tools for having a plan in place for someone to step up and make decisions if you're not able to make those for yourself, and to be able to express in a formal legal document what any preferences are for end-of-life care. In the backdrop, I also wanted to walk through if there aren't advanced directives set up, what does the law say about what happens next? And there's two main laws in Illinois that end up stepping in if there isn't someone who's already been named through a power of attorney document to step up and make decisions if you're not able to. The first, and I'll walk through each of these. The first is the Healthcare Surrogate Act, and the other is adult guardianship. Healthcare surrogacy is when someone does not have the capacity at a given time to make decisions for themselves about medical care. And at that point, a healthcare provider has to inquire into whether there is a power of attorney that's already been set up for healthcare. If there, after that reasonable search into whether there is a power of attorney that's been set up, if it turns out there isn't a POA that the healthcare provider can identify, then they have to make a reasonable search as to available healthcare surrogates. What a healthcare surrogate is it's someone named under the Illinois Healthcare Surrogate Act who would step into that role of decision maker for medical care if you're not able to make medical decisions. The law spells out an order for who those people would be who would step in to make decisions if needed. That order is first if there's a guardian of the person. So if there already has been a guardian appointed, that would be the first person who would step up to make medical decisions. If there isn't a guardian who's already in place, then the next preference would be for a spouse. If there's no spouse or the spouse can't be reached, then an adult son or daughter. Then either parent, an adult brother or sister, a grandchild, a close friend, or a guardian of the estate, as a guardian over finances if one has been appointed. As you can see, this order does set up a default for who the decision maker would be, if needed, if there isn't a power of attorney in place. But it might not be reflective of what your individual preferences are for who would be serving in that role of stepping up and making medical decisions if needed. Sometimes someone might prefer to have an adult child step in lieu of a spouse, or they might have a specific preference on which adult child they would prefer to step into that role. It's important. That's one reason why it can be important to have a power of attorney document set up for medical decisions instead of solely relying on this default under the Surrogate Act. because the law just does go through this default. And the power of attorney document can be a way to spell out and make it very clear for anyone who might be involved, from family or beyond in your life and in your medical decision making, to make it clear who should be stepping into that role and what your preference is. A couple of additional things to keep in mind with the Healthcare Surrogate Act. Um, it the standard for decision making under the Surrogate Act is that, again, the person who's making decisions for you, if they're stepping into that role, they are supposed to make decisions that go along with what they think you would have wanted, or if they don't know your wishes, then what they think is in your best interest. Some of those potential drawbacks, as I mentioned, are first that that order of preference that the law sets up by default might not reflect what you truly want. Um, Additionally, it only covers medical decisions. So I also had talked about powers of attorney for property, for finances. And again, with that, it would mean that there isn't someone in place for covering financial decisions, for helping make sure the bills get paid if you're not able uh, to make those financial decisions for yourself, for making sure that arrangements for housing, for signing a lease can get made if you're not able to do so on your own behalf. And then lastly, just to go back to this previous slide, there can be disagreements about among the people at the same level of priority. So if there are multiple adult sons or daughters, the law just sets them all up as that same level of priority for who would be stepping into that decision maker role. And there can be conflicts that can come up if it's simply left to any of the adult sons or daughters as to who actually makes that final decision. Having a power of attorney in place can prevent that kind of ambiguity and potential risk of conflict or disagreement by making your wishes clear on who you want to have step into that role. Then adult guardianship ends up stepping in for if there isn't a power of attorney in place, for stepping up and making medical or financial decisions if needed. So there are two types of guardianship. The first is guardianship of the person, which covers medical decisions and personal decisions. It's similar in scope to a power of attorney for healthcare in what it covers. And then there's a guardianship of the estate, which covers finances and property. That's similar in scope to a power of attorney for property. And what guardianship is, it's when a court ends up stepping in and appointing someone to make decisions on someone's behalf. That person, that decision maker, ends up being called a guardian when there hasn't been someone already set up as a power under a power of attorney to serve in that decision making role. So it again really comes up where there hasn't been that opportunity for advanced planning to get these documents set up and give someone else the legal authority to step up and make decisions if needed, and instead a court stepping in to appoint someone if there's no one else who's already been appointed under a power of attorney. For a comparison, just to clarify some of the differences between powers of attorney and guardianship. Sometimes the terms get used interchangeably, but they are quite different. Usually, a power of attorney is going to prevent the need for guardianship. That is, if you already have someone in place who has that legal authority to step up and make medical decisions and step up and make financial decisions if needed, generally a guardianship is not going to be needed. However, a power of attorney, either for medical care or for finances, can only be put in place while the person setting it up still has legal capacity. So they still have to be able to direct who and express those preferences on who they want, have clear direction on wanting someone else to be able to step up and make those decisions for themselves. So if they're already in a situation where they can't make decisions on their own behalf, maybe they've progressed further down the road to dementia or are in a medical crisis, at that point it's generally too late to set up a power of attorney document. Guardianship can only be put in place in contrast after someone's already lost that capacity to make decisions on their own behalf. So in that way, a power of attorney is a proactive tool that you're setting up in advance, whereas guardianship is a reactive tool. Something's already happened, capacity's already been lost, and we're needing to uh, find a decision maker, bring in a decision maker to step in. With a power of attorney, the person setting it up, the principal, stays in control. As I talked about earlier, that person keeps the ability to end those documents. With healthcare, end it at any time, and with property, end it any time that they still have capacity. Um, and they can also change that document. So if they initially set up a power of attorney, naming one person that they trust, and they later change their mind and want someone else a couple years later to serve in that role instead, they retain the control to create a new power of attorney and change that arrangement. In contrast, guardianship, it's the court who is stepping in to pick who the court believes, based on, evidence that the court sees, would be best suited to serve as guardian and make those decisions on someone's behalf. A power of attorney document is a private agreement that's just set up between the person, the principal, and the people that they're naming as agents. Whereas guardianship is a court order. It does involve a court proceeding and creates a public record in the court records, um, as opposed to it just being an arrangement worked out between individuals. Um, with with revoking powers of attorney, as mentioned, those can be revoked, whereas with guardianship, it requires a separate second court procedure for ending a guardianship, which is sometimes called restoration of rights. Because guardianship involves a court process, it can often be more expensive and time consuming, often needing to, have multiple court appearances, and make sure that court filing fees and any other related costs get paid. Powers of attorney, in contrast, are relatively easy to set up. Again, Illinois has standard forms, and there's also free legal resources like our office and some other legal services organizations that provide assistance with setting them up. And as a result, often more affordable without having to go through that extra hurdle of a court proceeding. And then last but not least, powers of attorney don't take away rights. So they allow someone to step up and make decisions if needed, but they don't legally remove any rights. And in fact, the person setting them up keeps many rights around revoking them or changing them so long as they have capacity. In contrast with guardianship, the person under guardianship, sometimes called a ward, gets a legal determination that they're unable to make decisions, and it can have some impacts on civil rights. Someone who's under, for instance, a full guardianship loses the ability to have a driver's license, and there can be some other related impacts under the law of having a guardianship in place. So just to recap and stress a few of these important points, if you don't have advanced planning, it can be hard and more difficult for loved ones to know what your wishes are and honor those wishes. It can create additional hurdles for making sure that the people that you most trust to make decisions on your behalf are the ones who are able to step up in the moment and make those decisions when needed. And it does, if you don't have these legal documents set up, it does create a risk that there could be the need for pursuing a legal tool like guardianship through the court system to appoint a decision maker if there isn't someone already set up through a power of attorney to step up and make important decisions if needed. So setting up powers of attorney can be very important tools for basically having a plan in place for if there's an emergency, and for making sure that your wishes are known, honored, and respected when the time comes that you might need someone to step up and make decisions for you. So I know I've maybe wrapping up a little bit quicker than anticipated, but As we noted, there's going to be plenty of time for questions here at the end. I've included our contact information on this last slide. So if there's any way that you think if there's any questions you have in follow-up that we're not addressing today, or if there's anything specific to your own situation that we wouldn't be able to answer because it's a more individual situation, you're very welcome to contact us at any time.
Thank you so much. Thanks, thanks for such an informative lecture. Um, Let me just move my screen for one quick second. There you are. Perfect. Now I can see you well. Well, thank you for that excellent presentation, Kate. It was very informative. I know I've learned why advanced planning is essential, not only for end-of-life care, but also for maintaining autonomy during life. The presentation covered powers of attorney for health care and property, living wills and pulse forms. We heard about the importance of planning early while the capacity exists and how failure to plan may lead to reliance on the Illinois Healthcare Surrogate Act or even guardianship, both of which can cause family conflict or financial stress, loss of personal choice. And that's all just really timely and really informative for not myself, just myself, but for our Rush Generations audience. So I'm going to open the floor for some questions and comments from folks. If anybody is on the call and has any comments or questions for our speaker today, please hit *6 to unmute yourself. And I know that we have a slight delay on YouTube. So I have actually a prompt for our YouTube viewers. If, how many of you have completed a power of attorney or living will, and what made you decide to do so, or what has stopped you so far from doing so? That's maybe a question that Kate and I would probably love to hear your thoughts on. If any of you have thoughts that you can share, just type your answers in the chat. Happy to feed that to our discussion. And then also imagine, if you're being hospitalized or unable to speak for yourself, who do you trust to make decisions? I think that that's another good something for us to ponder and to think about, like as we get started on this portion, why power of attorneys are so important as we move forward in any stage of our lives, but specifically as we are now maybe entering our 4th stage of life. So from YouTube, thank you for your presentation, excellent information. Do you have assistance in Spanish, is what they are asking.
Yes, our office, we have bilingual staff and provide services both in Spanish or English, or if there's another language beyond those two, we also have interpreters that we work with.
That's amazing. That's terrific. Knowing that we live in such a world city, and knowing Spanish is definitely going to be one of the major other languages that I know that we, as well at Rush, provide a lot of our workshops in both. So that's great to know. And again, for those that are joining us late or will be viewing this lecture at a later time, you can always reach out to the Center for Disability and Elder Law at 312-376-1880 or email info@cdelaw.org. That's info@cdelaw.org. And that's the same for their website, which is www.cdelaw.org. And that's specifically for our YouTube viewer that had that question and concern. So getting into some questions, I know I had some questions as why is it so important, again, to create a power of attorney while you still have that capacity? Because I think that that's something that I definitely want to explore with you.
Yes, with power of attorneys, it's only an option so long as you have the capacity. So if you're at a stage of for any reason when you don't have the ability to make and express your preferences, in that case, it's too late for setting up a power of attorney because, as mentioned, it's a tool that's designed to be reflective of your wishes. It's not a tool, it's not a document that anyone else can set up for you. It's not a document that a loved one or family member can say, I'm going to become your power of attorney. Instead, it's you yourself making that decision and saying, this is the person I most trust, or these people. You can also have backups, and that can be important. These people who I most trust to step up in this situation to make decisions for me. And those are very personal decisions, and it can be important to have those conversations with loved ones to make sure that they understand your wishes, make sure that everyone involved is most comfortable with that arrangement. And it's really that you're in the best position to have those conversations when you're not in an emergency situation, when you're not setting this up right before you have a health crisis, for example, or have a major medical procedure, and instead are doing it in advance, when you're able to be in consultation with all those people you trust, to set up that plan.
Awesome, terrific. Actually, a follow-up question from that actually came from one of our YouTubers is, can I complete a POA, a power of attorney, for healthcare and property on my own, or do I need to complete in the presence of an attorney?
Yeah, it's entirely possible to complete these documents on your own. And in fact, in Illinois, we have a really great online tool, Illinois Legal Aid Online, that can help walk through those forms with you if you want to set them up yourself. One of the reasons we provide legal assistance is that it can be helpful to walk through it with an attorney, to make sure that you're understanding everything, and make sure that it gets set up properly. As mentioned, with powers of attorney for healthcare, it does have to be signed by at least one witness who is not a family member, not the person that you're naming as agent, and not a healthcare provider, who sees you signing that document. And for the for the property power of attorney, it has to be signed by at least two witnesses who, again, aren't related to you and aren't the person named in that document as your agent. And that has to be notarized. So it can be helpful to work with an attorney, our office or another free legal resource. But there's certainly also the option, and that's why Illinois has standard forms for these, to try to make it as simple as possible for setting up these documents without necessarily needing to go through an attorney.
Thank you for that. I mean, that is very helpful, but also, great to another chance to remind folks that I'm sorry, what is your acronym again?
CEDL, CDEL.
CEDL, thank you. The CEDL offers some pro bono work in this area specifically. So please, if you have questions, again, reach out to them. A question that actually came in as well is, we've talked through other lectures that we've done about, I'm not sure if you're familiar, if you've ever heard of the Five Wishes document. Okay, great. So can you tell us, like, what would be the difference of somebody who's maybe has filled out Five Wishes versus a POA?
The main difference is legal enforceability. So five wishes is an extremely important type of tool to be able to document and really reflect in great detail what your preferences are and what your wishes are, what your values are. But it doesn't give someone the legal authority to act on your behalf. So, a power of attorney, that's really what it's doing. It's naming someone else who has legal authority to step up and make a decision on your behalf if you're not able to do so. And having the Five Wishes document or a similar tool can be a really important thing to have to help guide that person that you're naming in a power of attorney document so that they can, when they're stepping up to make those decisions that most align with what they think you would have wanted, they have that guidance in place. And that can be really important and really meaningful if a family member or other trusted person who's serving under a power of attorney is faced with difficult decisions. To have that reflects really in detail what your wishes, preferences, and values are.
That's so helpful. I never even would have thought of maybe just the legality aspect of that form. So very helpful to keep in mind, and why it's important for us to have our POAs. Um, Another question that came direct from our YouTube right now. My loved one doesn't like talking about end of life or thinking about these topics. How would you suggest I have a conversation with them about creating a POA, a power of attorney?
Yeah, and I'm so glad that you brought up how difficult these conversations can be. I think it ends up being a very personal and very individual kind of discussion that's going to be based on what you and your loved one, most are able to communicate about. It can be just a starting point to, and even like sharing resources like this, can be a starting point for opening up conversations. We've had people who, are able to bring their loved one to a presentation, and that can be a starting point for a conversation to just frame it as information, not as you're needing to set this up right now, but as this is some information for you to think about, and maybe they're not ready yet to set that up, and maybe they need some time to sit with some information. But just want to really validate that yes, these can be very difficult conversations, and very personal ones to have.
Thank you for that. And to our viewer who suggested this question, I would also encourage you to this lecture will live in our YouTube library that you can always reference it and always go back to it and share it with your loved ones, because it could be a great icebreaker to maybe start having those conversations. Just like Kate suggested, it is a very personal matter. So this could maybe give you some ways to have a discussion organically about something that is very important for all of us, I think, as we move forward. And again, we also don't want to create a space of judgment or feeling that this is that you're in a position of disadvantage because you haven't done something so far. This is all about information and trying to get it out there as widely as possible. And it's obviously never too late while you still have agency to take care of these matters. Another great question that came in from one of our viewers, which and I echo this, is can a written letter signed and notarized by a person by the person be considered a healthcare POA? This question comes up often in some of our Latinx communities that we serve and have been to and given workshops. And so this is actually, something I'm very interested in knowing about.
With powers of attorney, it's not required to use the standard Illinois forms, but it is recommended. Um, it really ends up depending on what the document says and how it's set up, if it is properly witnessed, if it does include all of the information it needs to, in terms of what the law asks for spelling out who's stepping up to make decisions when it takes effect, kind of making sure that it has the proper signature and witnessing. So it is possible to have a document that isn't the standard Illinois form, but it ends up depending really on the document and if it includes everything that's needed. So we usually recommend using the form just because hospitals and banks and other places that accept or that would be in a position to need a power of attorney document to be able to accept someone's ability to make decisions on someone else's behalf. They're very familiar with the standard forms. But it's not to say that it could still be valid depending on if the document meets all the requirements under the law.
Got it. So what would your suggestion be in this situation? Like if somebody goes to, does your website have these forms readily available? Or what was the other website that you mentioned earlier today?
Yeah, Illinois Legal Aid Online has a tool that can help walk through the forms, and at the end, it generates the filled out form. That can be a useful tool. The forms are also available, especially the healthcare power of attorney, that's available through the Illinois Department of Public Health's website, which is just the standard form where you fill in the names of yourself and the people that you want to name as agent and check the boxes indicating, your preferences on when it takes effect. And it also lists out, the place to sign and lists out the requirements for getting it witnessed. So that it could be beneficial to just make sure that it is properly set up by using the standard form. But again, that's not to say that you can't make a power of attorney without the form, because it definitely is possible, but there is some greater risk that it might not fully comply with what the law requires.
Great to know. Another YouTuber asked, if I choose to meet with an attorney for assistance with my POA for healthcare and property, do the witnesses have to be present?
Yeah, with how our office handles it at least, we meet privately with the client, the person looking to set up the documents. And then because a witness can't be someone related to you, and can't be anyone like a healthcare provider, for instance, we generally use our own staff as witnesses since none of us are, related to clients, and we're able to we're also covered by confidentiality obligations. So if you would be working with our office, and I'm sure many other legal aid offices handle it in a similar way, you'd be meeting one-on-one with our staff, and we handle making sure there's witnesses for getting the documents signed and finalized.
Terrific. So you go through Sudel. That is something something that is part of the process and already thought out for you before obviously these things take into effect or when you go in to meet or those final moments. Great. Um, for older adults, LGBTQ plus community, what legal issues could arise for that community for members that are that are not married? And for those that are legally married same-sex couples, why is it still important to have POAs in addition to marriage?
Yeah, thanks for that question. The first both of these questions are really related to the Healthcare Surrogate Act, and what it covers and what it doesn't cover. So, for the first question about some issues that might particularly affect folks in the LGBT community who aren't married to a partner who they might want to have step up into that role of legal decision maker, the Healthcare Surrogate Act is what steps in if there isn't a power of attorney that's been set up, and it specifies an order of preference. And it lists spouse and then adult children and then parents and siblings. And so if someone is not legally married, they're not able to step into that role of spouse, which would normally have the first order of preference. And so having a power of attorney for healthcare bypasses that default under the law. It says, no, this person, and if it's your partner, that person's the one who has the legal authority, not the people listed in the order of preference under the Surrogate Act. That person instead has the authority to step up and make decisions. If you're married, then that's not an issue under the Surrogate Act, but there are limits to what the Surrogate Act covers. The Healthcare Surrogate Act only covers certain medical decisions. When someone's in a situation where they need a medical decision maker and they don't have a decision-making capacity. But it doesn't cover other kinds of decisions, especially financial decisions. So if there isn't that power of attorney in place, even though a spouse might be able to step up and make certain healthcare decisions, there would be things that wouldn't be covered. So that's why it still might be important to consider setting up powers of attorney, even in a situation where you're married.
That's terrific. So yeah, basically that I mean that's very personal and dear to me, but also some of our Russian Nations members. So thank you for that. So basically, making sure that having a power of attorney even for those that are in same-sex couples that are not married to would help them in assistance when it comes to especially be that decision maker in medical decisions, but it still may not cover them. Or, but would depending on what kind of power attorney you did. But being married and not having a power attorney still gives you that privilege of making those medical decisions, but possibly not be an executor of their estate or financial. Is that what I'm hearing?
Yes, there might be limits on what they can step up and do. Even though spouses do have lots of rights, there's still limits as to what roles they can step into if someone doesn't have decision-making capacity. So that's where a POA can help fill in those gaps.
Awesome. And then is Citadel also a place where LGBTQ plus seniors and elder adults can turn to?
Yes, definitely. And we actually have I oversee our community clinics program where we're kind of on site once a month at various locations throughout the area, and throughout Cook County. And one of our locations is specifically targeted at being an affirming space for LGBT older adults. We work with the Center on Addison to be one of those to have one of our clinics on site there once a month. And then all of our staff go through training to ensure that folks are providing services in a way that's LGBT affirming at any of our other clinic sites.
Well, as I'm looking at time and questions have now slowed down, I want to take this opportunity to just give you a huge thank you for spending some time today with us today and giving us such information that is important, permanent, and that we all should think about. And definitely, hopefully, this lecture will serve our viewers today and those that will watch it later as a informative and tool to have those conversations with their loved ones. So, Kate, I want to thank you for joining us today. For those watching, just stay for a couple more seconds as we tell you about what's coming up next.
Thank you.
Thank you. So for our Rush Generations folks, I want to remind you of current and upcoming Rush Generations events. Let's start with our Walking with Ease. It's a guided walking program. Each week, the walking groups meets for 30 minutes to an hour to check in and learn information on how to incorporate healthy habits before embarking on a self-paced walk from 10 to 45 minutes. Our next session will be held on Wednesdays, Thursdays, and Fridays at the Garfield Park Conservatory starting August 20th through September 29th from 1 to 2:30 p.m. Please feel free to call our 1-800-757-0202 Rush Generations number to register. And I'm excited for that. The Garfield Park Conservatory is just beautiful. Next, we have Tai Chi for arthritis and fall prevention. This workshop helps participants improve balance while fostering mindfulness. Other benefits include relief of pain, stiffness, reduced stress, and improvement of quality of life. Offered in 116 one-hour sessions, the program has demonstrated a 47% reduction in falls. Each class is assigned with a focus on proper alignment of each warm-up exercise in Tai Chi form and can be adapted for seated positions as well. Our next session will be held on Wednesdays and Fridays through Zoom, starting August 20th through October 10th from 11 a.m. to noon. Again, feel free to reach out our 1-800-757-0202 Rush Generations phone to register for this course. Finally, I'd like to also remind you that Shulman Senior Voices aims to empower older adults to discuss what matters most to them as they age. It is important to share what matters most to you with your physician and loved ones. And Shulman Senior Voices wants to hear from you. So please consider sharing your wisdom as to why it's important for your healthcare team and loved ones to know your goals and wishes and what matters to you most. At aging.rush.edu/Shulman/collaborate-and-connect, or scan that QR code that you see right now on the screen to record on a mobile device or smartphone. Next, we'd love for you to join us in our next lecture, Immunization for Older Adults and What to Know. It's on Wednesday, August 20th, starting at 1 p.m. as always, in the same YouTube channel, and we look forward to seeing you then. And again, I want to remind you if you have any questions or to register for any of the workshops that I just mentioned, or if you have any questions on our programs, please reach out to us at 800-757-0202. Visit our Facebook page at facebook.com/Rush Generations. Thank you, and please take care.